Scaffold law accident in Queens. A scaffold accident on a Queens construction site can leave an injured worker facing severe injuries, lost income, and uncertainty about what comes next. New York Labor Law Section 240, commonly called the Scaffold Law, protects workers injured in elevation-related accidents when proper safety devices were missing or failed. This law applies to construction-related work performed at an elevation and can make property owners and general contractors liable when a covered safety device violation causes the injury. A worker does not have to prove ordinary negligence to bring this type of claim under Labor Law 240. Instead, the claim focuses on whether the required protection was absent or inadequate and whether that failure caused the accident. The scaffold law covers erection, demolition, repairing, altering, painting, cleaning, and pointing on a building or structure. It can also protect workers performing tasks in furtherance of one of those covered activities. Routine maintenance, manufacturing activity, and purely decorative work are generally not covered. Queens construction sites in areas like Jackson Heights, Flushing, Long Island City, and Jamaica can expose workers to serious scaffold hazards. Common causes of scaffold accidents include missing guardrails, unstable platforms, improper bracing, slippery walking surfaces, electrical hazards, and failures to inspect the scaffold before each shift. These incidents can cause traumatic brain injuries, spinal cord damage, fractures, crush injuries, internal organ damage, nerve damage, torn ligaments, and permanent disability. An injured worker may be able to recover compensation for medical expenses, lost wages, lost earning capacity, pain and suffering, and permanent disability. Wrongful death damages may also be available in fatal scaffold accident cases. Workers' compensation and a Labor Law 240 claim can be pursued at the same time because they are separate legal rights under New York law. Liability under Section 240 is placed at the top of the chain, which means property owners and general contractors are often the primary responsible parties. Subcontractors who assembled or maintained the scaffold and equipment suppliers who provided defective components may also bear responsibility. There is one narrow defense called the sole proximate cause defense. That defense requires proof that proper safety equipment was available, the worker was instructed to use it, and the worker's own choice was the only reason the accident happened. Labor Law 200 and Labor Law 241(6) may provide additional protections in scaffold accident cases. Section 200 addresses unsafe job site conditions, while Section 241(6) involves violations of specific industrial code safety rules. After a scaffold accident, it is important to get medical treatment right away, report the incident promptly, document the scene, and preserve witness information. A lawyer can also help identify deadlines that may apply to a personal injury lawsuit, a workers' compensation claim, or a notice of claim if a government entity is involved. Most scaffold law personal injury claims must be filed within 3 years of the accident, but some deadlines can arrive much sooner. A Queens lawyer handling scaffold accident claims can evaluate who may be liable and what evidence is needed to support the case. An attorney can also explain whether the facts support claims under Labor Law 240, Labor Law 241(6), Labor Law 200, or workers' compensation. L Sanchez Law Office, PC is a law firm based in Jackson Heights that represents injured workers in scaffold accident cases throughout Queens and New York City. For guidance after a scaffold accident, contact L Sanchez Law Office, PC, a law firm, at 646-701-7990, located at 3706 82nd Street No. 304, Jackson Heights, New York, 11372, United States.